Next up on our agenda is the impact of recent cases and OIG guidance, which will be presented by Brent Eilefson and Sarah Karlgaard. So Brent is the VP of Legal Affairs, Chief Compliance Officer, and Corporate Secretary at Upsher-Smith Laboratories. He's been there since 2004 and has the overall responsibility for the company's legal and compliance organizations and operations. Brent serves as an executive business partner and provides advice and counsel on a wide range of matters and the pharmaceutical industry generally. Sarah is GC for Canon Medical HIT Division, a leading innovator of enterprise, AI, and collaborative imaging solutions. As General Counsel, she leads the HIT Division's global legal, regulatory, and compliance departments and advises the company on a wide range of legal and business issues in a rapidly changing digital health landscape. So with that, welcome to Brent and Sarah. Take it away.
Awesome. Thank you. Can you hear us?
I can hear you great.
Yeah.
Wonderful. Fabulous. Well, this is great. Thank you so much for having us. I really think that what Brent and I are here to do is more or less reinforce that what Mark and Dulcie just went through actually matters in practice, and what we have done as practitioners in drug and device, how we pay attention to these things and take some action. So we're going to take a few minutes and talk about a few cases that have stuck out to us in the last little while, but mostly we intend to talk about what we've done with our companies in response and what we've been seeing and hearing from our colleagues in the industry. None of this is revolutionary, but I do think it's helpful to hear what a couple of GCs are paying attention to. That said, I know we have a bunch of wonderful practitioners online, so please do chime in with any questions or anecdotes, and we'll do our best to get to them as well. So with that, if you will please advance the slide. Awesome. So on the device side, you heard Mark and Dulcie really talk through the recent cases in detail, but I wanted to include a couple of them just in the presentation for context. I'm not going to go deep into them, but I think it's helpful to ground. We've got the one where the French company, it's an American, and its American affiliate really just wined and dined the heck out of some doctors overseas and then failed to report. Fairly straightforward on the false claims, but I think people were a little surprised that the Sunshine non-compliance doubled their settlement. We watched out for that. We noticed that. Second is the case of the South Dakota neurosurgeon / restaurateur. Here they got dinged hard on Sunshine again, over $1 million, because they essentially underreported the ownership interest. But here they did report the activity, they just didn't get the ownership interest remuneration. And I have to say, maybe it's just the local connection. I feel for the compliance team a bit on this one. The government obviously alleged that the sales team knew the ownership relationship well. But you could see a world in which the information simply doesn't get to the compliance team. Historically, the Sunshine reporting team is typically a bunch of numbers people just trying to match the receipts to the docs. But as we'll talk about later, we obviously need to do more than that. And there are some additional questions that I think we're all asking now. So more on these and how they've shaped our practices soon. But I'll turn it over to Brent, who's going to talk a bit about some drug cases and the guidance he's been watching.
Yeah, thank you. So similar to the device world, which I know we're steeped in deeply here in the Twin Cities, maybe less so in the pharma space, but Upsher-Smith has certainly been in the Twin Cities since 1917. So we've been around. There is drugs. There are drug pharmaceutical companies in Minnesota. And we like to have our voice heard. Certainly, the cases again, Mark and Dulcie spoke to Novartis. Even prior to that, Teva had got themselves into some problems. And as I look at these cases from a drug perspective, and in particular with respect to speaker programs, you can see where, as Mark pointed out in the fraud alert, you can see where the OIG is saying, hey guys, you're doing just fine. Why open this Pandora's box of potential compliance concerns? And this is rooted in history, right? So these actions of Teva, these actions of Novartis, and even on the next slide, the DUSA case as well, are all instances of past conduct. And you can advance the slide. There we go. But I would point out as a pharma lawyer, the pharma code, which has governed our interactions with physicians, has existed since 2002, and it was kind of a big deal when it was updated in 2009, and it's been recently updated as a result of the fraud alert. So the fact that these actions were going on and these physician speaker programs and other events were being held with the facts that we see as late as 2016, I agree, Sarah, that we as compliance officers may often be the last to know, but at the same time, if you, in the drug world, if you were still doing these activities in 2016, you were asking for trouble. And I do understand, Dulcie, as well, right? We don't always get the full story from these reports, but at least the appearance of impropriety is still existing. Next slide, please. So Sarah, again, I think you hit on it, right? And Mark and Dulcie, the False Claims Act, the anti-kickback statute, those are kind of the levers that get the federal government involved. But with respect to speaker programs, lunch and learns, whatever it might be, we are concerned about this increased use of the Sunshine Act, the Open Payments Law, to kind of pile on and double awards. And again, all of this is a lucrative industry for whistleblowers who, funny enough, sometimes seem to be whistleblowers in multiple cases. So they are, maybe it's their professional job is to be a whistleblower. And again, none of us want to be under a covert integrity agreement. We've not come close, knock on wood. But you read those, the restrictions and the requirements, and that's nowhere I want to be. Next slide, please. Sarah, if you want to add, I think this has probably been covered, but I think the key takeaway for us from a speaker program standpoint is the OIG is skeptical that these even have a reason to exist. Now, I would agree with Dulcie at that last point she made. Even in the drug world, there are instances where the in-person exchange, the in-person gatherings and exchange of information are much more effective, much more just leaves a lasting impression on what we're trying to achieve in the drug space. The challenge we see, for example, is converting a market from oral to nasal is a challenge Upsher-Smith is familiar with, for example. And you just can't really do that and help make that point about why or how this is an important development, in a virtual environment. Next slide. And again, as I mentioned, so the pharma code I did mention has been revised yet again, effective January 1st of 2022. And then just some data to kind of ground people on where pharma companies were at. Anecdotally, we are hearing roughly 20% of the physicians we work with, or the physicians we work with, are saying about 20% of their speaker programs are in person. So roughly 80% remain virtual. This is a fairly recent survey in kind of setting out where people stand, at least in the pharma industry, and some of the largest pharma companies are part of that survey. Again, I go back to say none of this should be surprising to anybody. None of the requirements of the fraud alert, all of this were things that we were doing starting in 2002, reaffirmed in 2009. So again, what we see in the fraud alert, the special characteristics that OIG has identified, most of that maybe required some tweaks, and we'll speak to that, but really was not a surprise. And I threw in the last bullet in case there are those of you out there. It is important that we hear this all the time at our little compliance events, the culture of compliance. Make sure you're training on your code of conduct fundamentally, so people at least have a baseline of expectation of compliance, and then obviously, with respect to speaker programs, with respect to other specific activities that you engage in, make sure you have policies and procedures and that you're training on them. Next slide.
Awesome.
Okay.
So in terms of some of the impacts that we're dealing with, we kind of look at this and go, and we pay attention to what's happening with pharma as well. They seem to be just a titch ahead in terms of what this all means and in terms of impacts and what we're doing. As we've mentioned several times, overarchingly, these are basic things. Don't wine and dine, keep it modest, all the things we've been reinforcing forever, but it's amazing how the cases continue. So in terms of some of the things I put together, first on the slide, I'm not sure it needs to be first, but it's what first came to mind when talking about culture of compliance. Make sure you have an auditing program in check. This is, of course, one of the 7 elements of an effective compliance program, but I think it's one that gets overlooked the most. And then you need to have some teeth. And this is really about finding the information before someone has a chance to bring it up externally, as well as creating that culture of awareness and compliance. If our salespeople see that we're checking their conduct and seeing action taken, they're of course more likely to course correct on their own. Second, and this, it's just table stakes, but use these cases, publicize them. So at our company, we have an executive compliance committee that meets frequently, and we start each meeting with compliance in the news. And we talk about these types of cases. The facts are interesting. I find it the most effective if you can pull some thread to connect it to the practices that you and your organization does, and how without those practices, you could see how this could potentially happen. Third, go through your checklist, check your checklist, ask the right questions. Are you asking the right questions of the right people? Do you ask about ownership relationship? That has to go on everyone's checklist now. Are you seeing repeat business at certain establishments? I think it's really helpful that you go through these activities and certainly check in. And then look at trends and analytics before you report. The government is apparently getting a bit more tech savvy as well as collaborative among its agencies. So it's important to do your own trends and looking at aggregate data, look at suspicious amounts, look at locations, et cetera. Next, reconnect with your first lines of defense. Brent touched on this as well, but make sure they get it. My department attends every annual sales meeting, and we present, and then we hang around, right? And it never fails how much the cases and presentations feel the same. You feel like you're just saying the same thing, but someone will always ask a slight nuance or some sort of question or pull you aside, and you know that it's a worthwhile endeavor. So I reinforce that for sure. And then finally, Mark touched on this a little bit too, and I recognize that there's a lot of importance in face-to-face interaction, particularly depending on the device. If it's an interventional situation, if there's a lot of complexity in training and those kinds of things, I recognize the importance of in-person events. I think you do get more out of them in a variety of contexts. That being said, pay attention to virtual opportunities presented by the pandemic. My sales folks, will push in person all the day long, but I have found it helpful, and it makes my CFO really happy to really look at the ROI on the in-person programs versus the virtual programs, because as you can imagine, virtual programs present far less risk from our standpoint. And we think that the regulators are onto this too. We think that they are noticing that we have managed to turn ourselves into a virtual world, and that then the in-person and some of the things that go with it are maybe less important. So we're watching that trend as well. So those are some of the things that we're doing on our end. Brent, do you want to take it home with what's happening on your end?
Sure. So next slide, please. Well, good. And thanks, Sarah. And interestingly, so when Sarah and I were speaking about this program and thinking about sharing stories and sharing examples to highlight to compliance committees in particular what we are facing in the drug and device space. So Sarah and I both have Japanese parent companies, and at least in my case, so our company was acquired by a Japanese company in 2017. Had no prior experience in the United States in pharmaceuticals. As you can imagine, that's a completely different space, the pharmaceutical world in Japan as opposed to the U.S. So I do think it's very important to have that line of education to your compliance committee, to your board of directors, especially in cases where the parent company or your ownership may lack experience in drug or device. So again, things we've hit on, just want to reinforce, if you don't have policies in these areas, speaker programs, whatever it might be, make sure you adopt those policies. Make sure if you have the policies, you're updating them, and read the fraud alert. Take a look at the suspect characteristics. Make sure that those are being addressed in your policies and your procedures. Make sure you have guidance around when to use HCPs, when to use your internal people. In the pharma space, we have trainers that are pharmacists, and we have trainers that are physicians or nurses, and those come prepaid, right? They're already on salary, and so adding the risk of using external healthcare providers is mitigated to a degree. As Sarah says, question whether or not you need to be in person. OIG thinks the virtual is fine, and just anecdotally from our company's perspective, we are having decent luck with the virtual environment, not just for speaker programs, but again for I guess what we call lunch and learns. Certainly, when you are sitting at your desk in an office, you are minimizing the risk of exorbitant meals or fancy or inappropriate venues, and again even alcohol, which pharma starting January 1st is banning from the educational exchange environments. And pharma, again, is guidelines, right? So as is AdvaMed, but there are states like California in particular that have said pharma, you must follow the pharma code. And presumably they're saying the same thing about AdvaMed. So as much as these are guidelines, you are expected to follow. I think we've hit on some of this, right? Mark may have mentioned, I think as part of his presentation, who's selecting your speakers? Is it your sales and marketing staff? Make sure that's not the case. Make sure they're being properly vetted by an independent group in your organization. We've seen historically issues with companies who are training hundreds of speakers. And do you really need hundreds, or is this just another avenue for you to compensate physicians and make yourself special as they are looking to prescribe for particular disease states? Same with our, what's their status? Are they high prescribers? That adds an element of risk. And make sure, right, you're training these speakers. You're training them on the products. You're training them on how to use the products. You're training them how to stay on label during their presentations. And that compliance training is critical. How do you keep them on script? And then how do you monitor these events to ensure that they stay on script? And if the speaker goes off script, are the sales reps or those in attendance trained to course correct and pull them back? all of that is important. Dulcie mentioned, documentation. We need to, as we look at speaker programs, there is a process that you are establishing a need. You're pitching, your commercial team is pitching to the compliance department the need for a speakers program, or an ad board or whatever it might be. And you are, as part of that process, doing a fair market value analysis of the compensation paid to the speakers or the participants. So it's important. And then I guess my one final point, at least, on the Sunshine Act. So we, for better or worse, the compliance function in our company does the Sunshine Act reporting. So we see and first of all, it's very important that you have a system, a finance system that feeds the information that you need into some sort of reporting tool for the Sunshine Act. As part of that process, we found it very helpful to have compliance involved, because not only are you seeing all of the expenses that are being sent through, and at that time you are able to I'll say, audit for inappropriate spend, audit for inappropriate trends. For example, doing 12 speaker programs at the same restaurant in South Dakota, I would hope would have raised a flag in somebody who's reviewing those expenses. May not have ultimately revealed who owned the restaurant, but might have been the only one around that was an appropriate venue. But in any event, it gives me a little greater comfort that I've got a director of compliance looking at, who also happens to be a former CPA. So she likes numbers. I'm not a number guy. But that, I think, is a helpful peek into how our reps are doing their business. So ultimately, at the very bottom, just again, respond to compliance concerns, adapt as you need, tell different stories as they arise, stay in touch with your outside counsel, who are paying maybe even closer attention than we are in-house. We sometimes have a few other things going on. And that's it for that slide. Again, these are just repeat of the earlier points. OIG is interested in this stuff. FDA, FTC, they love pharma and device. I had hoped that they would move on to the Googles and the Microsofts of the world. I think they have, but not as fully as I had hoped. We've got a fair number of issues that we're dealing with the government, none of which we think are worth the government's time. And of course, the subsequent private plaintiffs that like to get involved make things even worse. So none of this is fun to be involved in.
Awesome. Well, I don't know. I mean, we're a little bit ahead of schedule. I don't know if anyone has any questions for us. Feel free to add them in the chat. One thing I will anecdotally add for any digital health lawyers who are out there, right? So we develop at my company medical imaging software. We're very much a medical device, software as medical device have for a long time, and so fall squarely within the AdvaMed code and do everything we can to comply. But one of the fascinating things we've encountered as a department as of late is with kind of the influx of digital health investment and innovation. There are a lot of companies who are just dabbling, and they don't find themselves, or they at least don't conduct themselves as if they are subject to these codes of regulations. And so that's just a unique situation. I find myself as a compliance leader and legal leader is trying to kind of navigate our sales folks to the hybridized trade shows where Microsoft or, Google shows up and they're giving away a lot of things, right? And so we're watching that. That's a trend we're most certainly watching as the full-scale tech med device companies. I just thought that was maybe something worth noting for the other digital health lawyers who are out there.
Thanks for that, Sarah. We do have one question that came in, and then we're going to move into actually wrapping up some questions outstanding from the previous presentation. But for Brent and Sarah, there's a question about who in the company should be selecting speakers and any recommendations or practices that you'd recommend there.
Do you want to take it, Brent? I can add, or you want me to go?
No, I can. I think so. What we train our sales reps and our commercial team on is they can, because they're the front line, so they know who's good in a jurisdiction. They know who the best, migraine doctor is in Chicago. But they are limited to only referring that name of that expert to our scientific team, our medical affairs folks. So the commercial team can make recommendations. They cannot approve who are actually the speakers that are selected and trained. Again, obviously their opinion has weight, but the formal approval is not in the sales and marketing function. So we limit that to our medical and compliance teams.
Yeah, we function very similarly. We have a policy and process. We call it the throw it over the fence, right? Like suggestions are fine. They're on the front lines, but we actually have a process on the back end that keeps sales and marketing really out of the ultimate selection, so that we've got the identified criteria upon which we would ever consider someone based on their talents, expertise, familiarity, those things.
And just, I think I know years ago when we first started doing speaker programs, we ran afoul, I would say, of this idea that you should only train really the speakers that you need. I think we thought, oh, Jesus, this is going to be huge. We trained, 100 and some speakers. And I think we learned not only do you not need that many speakers, and of course OIG would say you don't need that many speakers, but you really learn to look for your geographic experts. You look for your the folks who are expert in their field, whether they're physicians or whether they're nurse practitioners, whatever it might be, in the Midwest, for example, or in the I suppose the East Coast is a little bigger, but you pick your jurisdictions, you pick your expert. And it's not a surprise when those names come over the fence, right? It's like, oh yeah, well, it's Dr. Diamond in Chicago. So it's a lot more efficient. You save a fair amount of money because you're not training speakers that you ultimately never use, and of course you lower your risk in having too many speakers trained. But who they are, it tends not to be a big surprise. And it is it is an effective tool to have these peer-to-peer conversations, with speaker programs in particular. So it's, again, you want to have a well-documented process, and part of that is as well a fair market value analysis. You don't want to be paying. You see Novartis, under a corporate integrity agreement, limited to $100,000 a year, or $10,000. A speaker, I think it was, but the one way to help that space is to ensure that your budget is fairly small. So when you do a fair market value analysis, when you hire an appropriate number of doctors or healthcare practitioners, again, you're both limiting your compliance risk and you're making your CFO smile.
Wonderful, thank you, Brent and Sarah. We're going to take a 15-minute break now. Our next program starts at 9:45. That's deploying a compliance program and performing investigations. But because we had so many great questions asked during our first session, recent FDA, AKS, and FCA cases, we're going to spend some of that break revisiting those questions. So I'm going to invite Mark and Dulcie back. So feel free, if you're not interested in those questions, to grab a cup of coffee, check some emails. Otherwise, we're going to spend about 10 minutes on questions and then 5 minutes so everyone can run to the restroom if they need it.
Thank you. Appreciate the encore here. Not quite like your favorite band playing a few more songs at the end of the show, but a little bit more nerdy. But yeah, Dulcie, I'll just kind of run through a few questions, and then we're going to take a break as well, and we'll be back on. So one person asked regarding the Medicare case, and this could go for any case, should any blame be placed on the physicians who allowed themselves to be bribed? And you know, we don't know that case intimately. We've read the pleadings, but that's about it. But it suffice it to say, with the anti-kickback statute, if whoever's offering the bribe or receiving it, there's accountability on both ends of the transaction. So, you know, that's something we remind clients of often. It's because a lot of times you'll have a situation where our client, the manufacturer, may be dealing with a hospital or someone like that, and they're kind of pushing them on fair market value issues, saying this is fine, or we don't need all this detail in our SOW. And it's like, well, actually you do, because it's required by the safe harbor, and we're all in this together. So anything to add there, Dulcie?
Yeah. So the question asked, you know, I think the implicit in the question is, why are we talking about the manufacturer and not talking about the doctors here? And I will just say that in my practice, I have defended many doctors who are accused of bribing. So it is not solely that these cases get focused on manufacturers, although typically the manufacturers have deeper pockets than the doctors do, even though a lot of doctors do quite well financially. They're not big companies. They're usually smaller physician practices. And so sometimes that's what drives litigation. It's a real sort of crass, you know, kind of determination of who's got the money. I've been involved in many cases though, where I've got cases where both the manufacturer and the doctor are defendants in the same False Claims Act case. One of the biggest False Claims Act matters I have ever handled was a case that was venued. Well, first it was in the District of Massachusetts, and then went up on appeal in the First Circuit. And we defended, I think there was the key time relator had, and this was one of these combination off-label anti-kickback cases, had alleged claims against 106 consultants who had consulted with a device manufacturer. And we had most of those consultants as our clients in the case. And so it is certainly true that the doctors are just as culpable and they're just as likely to get sued. It's just there's a little bit more incentive for these key time relators and the government, frankly, to go after the manufacturers, because that's where the money is.
Yeah, great comments. I think that's just another practice point, more on the transactional side, but for the manufacturers out there, you know, you want to know who you're retaining. You want to vet them. You're going to want to use the SAM checks. You're going to want to see if they're on the OIG exclusions list, et cetera. Because if I don't know what's going on, you know, with prosecutors and whatnot, but perhaps certain people are on their list, right? That they're thinking this is someone that's been wrapped up into some issues before. So we're going to keep an eye on them. And if you show up on open payments, paying that person, that could be an issue for you. So you want to be careful with who you retain. You know, there could be a lot of metaphors we could get into there, but you're ultimately partnering with that individual. So be careful. The Medicare case kind of sparked a lot of questions. There's another one. Someone asked, are there additional details about what discounts were at issue? And that was a case where they talked about tying. And just to talk a little bit about the discount safe harbor, at one point, products couldn't be bundled. Then the rules changed. Products can be bundled as long as they're part of the reimbursement of the same payment methodology, and the discount safe harbor requirements are met regarding disclosing any discounts and informing the buyer of their duty to report said discounts to payers. So, you know, they didn't get into the detail in the pleadings on those discounts. I suspect that this kind of goes back to Dulcie's point, where it was a kitchen sink complaint and they very well could have been lawful. We don't know. Perhaps maybe they were fine in meeting the discount safe harbor, maybe they weren't. I don't know. If the seller, if Medicare didn't inform the buyer of their obligation to report discounts, for example, associated with bundling or tying, as they call it in the complaint, then they'd fail the safe harbor test.
Yeah, I mean, I think it was the specifics that I'm aware of is that it was the provision of free devices in exchange for other purposes. So, and the government, or at least the relator, felt like the discounts were actually allowing free product to be provided.
Great. Another question about travel perks, and I believe that was also Medicare. If I'm remembering the complaint right, don't quote me on this, but I think they were talking about a $10,000 business class ticket. I can appreciate doctors traveling from Europe to the United States need leg room. I think, you can look at, are you paying for Delta One, which is like a very elite travel class? It's the top for Delta, for example. I don't know if any higher with maybe United has something that's like that, but versus just more of a business class ticket that is not, one of these deals where you have a bed essentially and your own small kind of partitioned room, if you will, on the plane. So, I mean, I think you need to, as a organization, start to think about what sort of perks go over the line in terms of travel. What about, you're going to be at the Ritz-Carlton versus a Hilton or something. I think you need to establish a policy where the expenses are reasonable and not intended to be some sort of over the edge inducement. I don't know, Dulcie, if you have anything to add there.
Yeah, I mean, I think the thing that struck me about Medicare was that they not only paid for the tickets, but they paid for spouses and girlfriends to go along. And once they got there, I mean, it was like, it was trips to France to this big research society meeting. And when they got there, it wasn't just attending the seminar. They had wine tastings, I think even in some cases kids were allowed to come along.
Mm-hmm. That's right.
There was all kinds of sporting events. It was travel / vacation, not just we're buying a ticket for this doctor to come and speak or to attend an event. It was it really kind of has some of those. I do a lot of Foreign Corrupt Practices Act work, as well as work in this space. And one of the things we look for, we've got sorts of key things that we look for when travel expenses are paid for when we're doing an investigation into potential FCPA issues. And, does a spouse come along? Are there these entertainment venues that are involved? Are there a lot of lavish travel perks that make it look more like a vacation than like a legitimate business meeting? And this one had all the markers that we look for.
Yes.
Yeah.
And again, the complaints are kind of blending together a little bit in my mind. I can't remember which one it was, but they actually had like what appeared to be travel brochures, something that, you would have seen from a travel agent highlighting trips to Portugal and Ireland and Hawaii. And it was kind of like, well, this is clearly has there's an ulterior motive involved. So, be careful with those types of collateral that would go around. It shouldn't be, like Dulcie said, it shouldn't be a vacation with the family. And I do recall now actually that they had the families going along as well and covering their expenses. Another comment, commenter said, can you comment on the consulting agreement issue? The allegation was that it was bogus consulting, that work wasn't performed, no one followed up on it. And this kind of goes back to, you can go back to 2007 DPA with orthopedic makers, where same allegations there where consultants were put on retainer and never performed work. So that's one reason we advise against ever paying retainers. I mean, there may be possibly some sort of scenario where that could work, but generally you should just pay these folks by the hour. They should submit an invoice detailing what they did, and then you pay them for that. there are situations we've seen where you may have a physician that is maybe even retired and they're working for the company as a chief medical officer, and they're working significant amount of hours, and there's maybe some sort of retainer arrangement there, but generally 99% of the time you should just be paying by the hour, and there needs to, even if you're paying a retainer, you're going to need to reconcile that what you're paying them is for work that they actually performed.
I think we're running out of time with our Q&A.
All right.
So we'll hand it back to Mary now.
Great. So we're going to take that 5-minute break. We have some great hold music for you. So we'll see you in about 5 minutes.
Thanks.